Welcome everyone to the webinar. Thank you very much for joining. This is the free webinar on the essentials of legal protection for coaching, and we're going to go over the kind of the three major blunders that you want to avoid as a coach or a healer that can kind of leave you legally exposed and stuff. And I'm glad you guys were able to make it, and thank you to those of you who are watching on the recording as well. I'm going to jump right in and share my screen in a second here. Okay, so let me see. I want to make my video come back. All right, can everybody see my screen okay?
Yes.
I can,
Okay.
yes.
Yeah, and I'm not too formal about all of this. If you have questions, just jump in and ask, raise your hand, wave around, yell at me, whatever you need to do. If you have any a lot of background noise, then just go ahead and please unmute, but otherwise it's fine to keep yourself so we can all hear each other. So,
Okay.
So yeah, there's our introduction. And one thing I want to start off with is by letting you all know that the law, and I know this is easy for me to say because I'm an attorney, I've been doing this for 20 years, and so I've had the education and the experience. So for me, it's not scary and intimidating, but it really doesn't have to be scary and intimidating for any of you guys either. When it comes to spotting legal problems and implementing preemptive solutions, it only requires a few basic skills. And those are just common sense and the ability to do some research, observational abilities, communication skills. You need a detail-oriented outlook and a can-do attitude. And you guys are already looking at running coaching and healing practices, already building practices on your own. You guys already have amazing talents that I'm in awe of as far as your ability to help clients and do good in the world. And so as far as I'm concerned, you guys have these skills in abundance already. So then it's just about learning a new subject matter. And learning a new subject matter is just about listening to the experts. So you already go to experts for technology problems or learning your marketing, your business planning and paperwork. I mean, there's plenty of things where if we are not the expert ourselves, then we head to the experts to learn it. And a lot of our skills, our skill sets across our fields of expertise are very transferable. So, I mean, you saw the kind of skills you need to implement preemptive solutions and to have a positive outcome on the legal side of your business. I really think you guys already have those skills. So talking to folks like myself is really the great first step, and that's how you get into making sure that you're set up properly. I do want to talk a little bit about who am I. My name is Ian Foster. I got my law degree from the University of California, Davis in 2001. I'm a licensed attorney in the state of California. I have clients in California and all over the United States, a couple in Canada too. I can only perform certain legal services in California because that's where I'm licensed, but there's a lot of stuff I can do to help people around the US and around the world. My wife and I, Heather and I, founded Personal Empowerment Services. My wife actually started Personal Empowerment Services going on 20 years ago. She's a licensed therapist and a coach, and so she's been helping people for a long time, and together we have 40 years combined experience in the legal therapy and coaching professions. So that puts us in a unique position now to specialize in helping coaches, healers, and therapists and folks make sure that they're set up properly so that they can go have the positive impact on the world that they want and deserve to be able to have. I actually got into this 4 or 5 years ago when I met my wife. Like I said, she's a therapist and a coach, and so when she got married to me as an attorney, she said, hey, why don't you go ahead and look over my business structure and make sure I'm set up properly. I thought, great, I'll do that. I have experience in business entities and taxes and a lot of different things. I worked for the government for a long time prosecuting tax cheats, and I have a private practice, and so I have an interesting array of knowledge. So I took a look at her business and I realized, oh crap, this stuff is a lot more complicated than I thought it was going to be. It turns out the whole coaching and therapy practices and professions are a really dangerous legal minefield. For coaching especially, actually turns out to be much more dangerous than it does to be a therapist. And so I found a lot of things in her business structure that could be set up much better. And so I got her business structure cleaned up and set up better. And then I've had to work on my own business structure too. I'm an attorney and a coach, and so I have to, make sure things are pretty tight and separate between my legal practice and my coaching practice. We had to make sure that we had good separations between my wife's therapy practice and her coaching practice. And so that's how I kind of started in my expertise. I had to become sort of an expert on all of that just to get her stuff and my stuff set up properly. And then I started getting more into coaching and meeting a lot of coaches, and they started asking me questions, and I slowly, developed into kind of one of the pioneers in this new field of law through doing that. It was all came from meeting the love of my life and wanting to help her out. So it's just interesting the twists and turns that our lives take and how we get into the stuff we do. But at this point, there aren't very many attorneys doing what I'm doing, so it's kind of a new field of law. And it's a pretty exciting field, I think. I love working with the people I do. And so, talking about why I got into this, you heard a little bit about my history. Also, because this is where my passion lies. I absolutely love the coaching industry, and I meet at conferences and on calls and webinars like this. I meet so many coaches and healers and therapists who I just absolutely love these people. I've had coaches and therapists who have helped me in my life tremendously. You guys are the kindest, most heart-centered community with gifts and talents that I'm in awe of. And you guys are making a difference in the world in like actual tangible ways. You're changing your clients' lives. The world is a better place because of folks like you in real ways. And to me, that's just awesome. I'm in awe of it. And I really just want nothing more than to see you guys succeed and continue to make your clients' lives better and everybody else's lives better. So because I've gotten into this specialty too, and one of my motivations, I love the folks I meet and the clients I get, and I'm passionate. Their passions become my passions. They want to help their clients, so I want to make sure their clients get the help they need. I've also now seen what happens when things go wrong. And it's really not pretty. Just the smallest, most innocent seeming legal mistake, or maybe it's just some lack of knowledge, a little bit of ignorance about the legal limitations for coaches. Sometimes it's just a small mistake in a contract that was not carefully worded, not understanding the different types of coaching activities and the consequences that go with it. Client harm is something that happens. None of us ever intend to harm our clients. But from a legal perspective, it can be much easier to harm a client than you might think. A lot of it is just about the client's perception of what happens. If the client has something going on, a trauma in their past or some issue in their past, it can be very easy to trigger something and cause harm by saying something that was otherwise perfectly innocent and nothing wrong with it. So it's like I said, it's just not pretty when that stuff goes wrong. I don't want to see any more horror stories. I don't need any cautionary tales. I already have plenty of examples, for my marketing, so to speak, of things that can go wrong. I don't need to see any more of that. I want to see the industry thrive. I want to see the coaches thrive. I want to see the community thrive, so that we can all keep building a better and more loving world together. And so to do that, your business needs to be protected, and knowledge really is power there. Knowledge is where that all starts. We can overcome the legal challenges, we can steer clear of trouble, and we can make sure we have confidence and peace of mind. And once you get the business side and the legal side taken care of, you can really just relax and just get back to helping your clients, which is really the whole point. So I'm going to jump here into my little legal disclaimer. You can kind of consider this your first lesson, so to speak, on being on a legal webinar for coaches. As an attorney, I'm obligated to put up a disclaimer like this. So it's something I have to go through, and then hopefully it gives you an idea of the kind of things that you could have in your business too. So this webinar is not intended to be legal advice. It does not constitute legal advice. This is education in nature only. By showing up to this webinar, it does not mean that you and I have an attorney-client relationship or that you have an attorney-client relationship with our business, Personal Empowerment Services. We cannot guarantee any specific outcome or results from this webinar. We cannot guarantee confidentiality for what you say in this webinar. Since I'm not your attorney, this is not a privileged communication. And of course, I can't stop anybody else on the webinar from doing whatever they want to do. So just be aware of that. You agree not to hold us for any losses you might incur as a result of actions or decisions in response to the webinar. And this webinar contains my work product and intellectual property. So of course you won't give it away or sell it away or pretend that you own it or try to profit off of it. So now that the legal stuff is out of the way, let's get into it. So that what you can expect today, we're going to talk about the 3 biggest blunders that keep you legally exposed. And those are, and of course there are more, but these are 3 of the big ones. But 3 of the major ones are running afoul of state law limitations, using incomplete or even damaging contracts and contractual language, not understanding the legal issues that are specific to groups and live events. We're going to have instruction, and there's live Q&A, like I said, ask questions anytime, and then some bonuses for those who are able to stay till the end. So a question I get a lot is how can there be legal limitations on coaching when coaching doesn't require a license? So in the US, Canada, the UK, what we call the common law countries, you generally need a license to be a therapist, a psychologist, or a doctor, a lawyer. In all those countries, you generally do not need to be licensed to be a coach. So the question then is, well, if we're not licensed, how can there be legal limitations on it? And it works sort of like this. Here's a little visual diagram. So when the government says you need a license to be a psychologist or a therapist, or a clinical counselor is a new one that's propping up in some jurisdictions, what they do is they say you need a license to engage in a certain kind of activity. And so in this representation, the red circles would be the activity you can engage in if you have those different licenses. And so if you want to get into those red areas, you have to have that license, whichever one it is that corresponds to it. As a coach, you can operate in the gray area of unregulated activities. So there's lots you can do in the gray area as a coach, but what you cannot do is venture into those red areas that are reserved for people who have licenses to do them. So in reality, I mean, this is just a little visual representation. This representation is probably a little more like what reality looks like, because unfortunately those legal definitions they draw are not as clear and distinct as they could be. So there ends up being a lot of overlap. So, you see it tend to look like that. So if we get into the first blunder, which is avoiding state law limitations, I'm going to give you a few examples here drawn from, these are all drawn from actual laws in US states, various US states, but they are very similar across the Commonwealth countries. So if you're in places like Canada, Great Britain, Australia, New Zealand, you're going to find very similar legal definitions. So a lot of my specific examples in this webinar are drawn from United States law, but the principles apply across the different Commonwealth countries. So if you've ever helped a client examine an interpersonal relationship so they can achieve a more adequate or satisfying life in their marriage or family, well, in the state of California, you would need a therapy license to do that. And that's taken right from California law. And then you can see here's examples from New York and Texas too. So those are just kind of some examples of the activities that would fall in the red areas on those diagrams where you would need licenses to do them in different jurisdictions. And it kind of shows you how every jurisdiction has slightly different laws too. So like I know in Canada, the different provinces will have different laws. I'm not entirely sure how it works in the UK. Adele, do you know, like, are the licenses, is it at the whole national level or local or? Not sure. I'll have to do some research on that.
No, I don't know. I'm not functioning past family and friends at the moment, so
Mm-hmm.
I'm kind of interested in this before venturing out, and
Right.
you've called me before I've got to that stage, so it's kind of scary
Yeah.
to hear what you're saying.
Yeah. Well, some of this can be kind of overwhelming, but our whole point here, and I'll talk about this again in a few minutes, is to really make sure that we overcome any challenges and make sure that you can use your gifts and talents. So, I mean, some more examples here. These are what you need psychology licenses in various jurisdictions. Here's one that kind of jumps out to me, and I've had clients in Wisconsin. So in Wisconsin, you need a psychology license to help a client understand the unconscious processes involved in their intrapersonal or interpersonal dynamics. So, and you know, as coaches, what do? We help people with their inner game is kind of the catchphrase that they use. And what is that if not helping someone with their unconscious processes? So if you read these laws very strictly, it can be a little bit overwhelming. And then these are some examples of this new licensed profession that's been around for a few years now called professional counselor. One that jumps out to me there is in South Carolina, you need a professional counselor license to help to counsel a client about their vocation, substance abuse, or personal development, which is super broad, obviously. So if you read that literally, it almost sounds like you need a license in South Carolina to basically talk to anybody about anything. So these legal definitions, they matter in the sense that there's a lot of, everybody has their own understanding out there about what the difference is between coaching and therapy, or the difference between coaching and medicine, or the difference between coaching and law. You know, and that's a very common question I get is, what is that difference? Or people often, you know, they'll tell me what they're sure the difference is because everybody's heard it or read it or seen it somewhere. But whatever you've heard about the difference between coaching and therapy, or coaching and one of those other practices, from a legal standpoint, you can pretty much throw all that out. The only thing that matters from a legal standpoint is what the government defines. So if a government says that you need a therapy license to clean your client's toilet, then you need a therapy license to clean your client's toilet, no matter what else you've heard. Now, I haven't yet seen that, but you know, but the point there is that they can define therapy or law or medicine any way they like, and once they've defined it that way, that's what it is for legal purposes, and you need a license to go within that definition to do those activities. And the controlling law is the law where your client lives, not where you live. So if you live in one location and you're working with a client who lives somewhere else, then it's the law of your client's location that determines whether or not you're practicing without a license. And then the law also trumps what your contract says. And so the phrase I use here is, you can't call a sheep a dog. You and I can contract to purchase a sheep. I have a sheep, you want a sheep, and I'm going to sell it to you, and we write up a contract and you pay me, and there you've purchased a sheep from me. But for some reason we decide in the contract that we're not going to say sheep, we're going to say dog. We're going to say you've purchased a dog from me. Well, we can say anything we want in the contract, but legally you have still purchased a sheep from me, no matter what we call it in the contract. And it's the same thing when it comes to the difference between coaching and therapy. Your contract can say up and down, right and left, front and back, that this is coaching, not therapy. But if the activity you're performing still falls within the legal definition of therapy, then it's still therapy no matter what your contract says. The governments do enforce these laws. Now, they can't audit everybody. So, you know, it's kind of like getting audited for tax purposes. They can't audit everyone or go after everyone. So they are relying on voluntary compliance from the population. And so if you're not aware of the laws, and if you're not at least making a good faith effort to be compliant with them, then you're playing Russian roulette with your business. You know, and the more you operate, the more likely it is that the next client you operate with could be the one that somehow gets you to the attention of the state authorities. The penalties can be very steep. You're looking at $10,000 to $20,000 fines just for one instance if you get caught practicing without a license. 500 hours of community service, or even 6 months in jail. The jail time is unlikely unless you've caused some client harm. And some of this kind of depends on the attitude you have. You know, these folks who work for the government who might be looking at your business to find out whether you're compliant, they're human beings like anybody else. They don't necessarily want to go around throwing folks in jail, hitting everybody with fines. They just want to do their job and go home and have dinner with their family, right? Now, so if you're nice to them, if you can show them that you've researched the law, if you can show them you've attended webinars like this, that you're making a good faith effort to understand the law and be compliant with it, you know, then you might be okay. You might get off with a slap on the wrist or a warning or a little bit of community service. But if you're a jerk, you know, if this state auditor shows up and wants to examine your business records and you say, hey, screw you, I can do anything I like, you can't tell me what to do, well, you can guess how they're going to respond to that, especially if maybe they've had a bad day themselves. They probably won't take time too kindly to that, and then, you know, now you could be looking at huge fines and jail time because they have the power to do that. So, I mean, it's like a lot of things else in life. If you treat someone nice, most of the time they're going to be nice to you. But I have worked with some coaches who have had a pretty rough attitude about it, you could say, where their attitude is, well, if the government comes after to me, I'm going to tell them to go away, you can't tell me what to do, get out of my face, government man. Well, you can say that to the government man if you want, but it's not going to go well for you. But if you are cooperative and polite and you're making a good faith effort, then you're probably going to be fine. And then the other thing they can do is they can actually shut down your coaching practice. They can get an injunction, which is a court order to shut things down. But the whole point here is to make sure they don't do that. And I did kind of want to hit you guys with all of that information, but I know it's overwhelming. It can be scary, but the point here is not to get discouraged. This is all about risk management. As a coach, there is no zero risk in the coaching business. So we all need to put that aside right now. Zero risk is not attainable in the coaching business. There will be some risk always. As long as you're dealing with people, as long as you're dealing with government laws, there is some risk. So it's all about how much risk can you tolerate and how are you prepared for it and how are you going to react if the government comes and talks to you about it. Like I said, you need to make a good faith effort. Show them, look, I have researched the laws myself. I've taken webinars and classes. I'm trying to comply with it and make sure that my coaching doesn't encroach too far onto these licensed practices. As long as you're doing that, you're probably going to be fine. But like I said, if you don't make that effort, if you don't do any research, you don't even try, and you have a bad attitude with the auditor when they show up, then things could go very, very bad for you. So, you know, have a little bit of risk, manage it well, and make sure you have a good attitude about it and a good faith effort. Yes, Adele.
I just query. You're saying about the government coming to audit these things. Is that the government from where the client lives then?
Yeah. So in general, it would be. And so the working across national boundaries can provide you a certain bit of of legal protection. So, for example, you're in the UK. Let's say your client is in Canada. And let's say let's say maybe that you have crossed a legal line in Canada without realizing it. And, you know, the coaching you did encroached a little bit too much onto some licensed practice in that Canadian province. I'm not saying that you should flout Canadian law or not make an effort to be compliant, but as a practical matter, the United Kingdom is not going to extradite you to Canada to face prosecution for that. You know, you didn't murder anybody. You're not a terrorist or anything like that. So this is not the sort of thing where they're going to cross the ocean and have you shipped back and sent to jail to face trial for anything like that. This is more of a risk of the government coming after you when you and the client are in the same location, because then, you know, it's the law it's the government. The law that applies is the law that where you live because your client's there also, and the government's right there. So that becomes more of a risk. Or you know, if it's nearby jurisdictions. So if you're in one U.S. state and you're dealing with a client in the state next door, then, you know, that's a risk. So physical proximity definitely can increase or decrease the risk. So that's a good question.
And I have one other question.
Yeah, please.
The difference between coaching and counselling is a tricky one. I don't. How do you define that?
Well, from a legal perspective, there's only one answer to that, and that the counseling that requires a license is whatever the government says it is in the location you're dealing with. And then coaching is something else, is not that. There is no legal definition of coaching anywhere that I'm aware of. So coaching is whatever you want it to be, as long as it's not encroaching on whatever that legal definition of counseling is. And that legal definition of counseling is going to be a little bit different everywhere. Unfortunately, there's no universal law. So, you know, but there are some general principles. I mean, you know, most of the legal definitions of therapy or counseling have to deal with often if you're doing with relationships, that can be a little bit more dangerous. If you're dealing with anyone that has a mental health issue, you're more likely to run afoul of a law. Even if your client has a mental issue. What's that?
How do you know?
Well, you don't always know. You don't always know, and I don't necessarily recommend that you ask either. I mean, there can be circumstances where you can ask, but it can be tricky because you don't want to later be accused of discriminating against the client based on a health issue. It's kind of like asking them, you know, what their race or religion is. Those are kind of, you know, it can be a no question. So you don't always know. So you have to be careful. Part of it is I encourage people to get training on mental health issues, on how to recognize them. That's not training that I offered, but I think there are places that offer that sort of training, and then you can start looking for the signs of it in a client, and then try to redirect them into, you know, licensed therapy.
Okay.
Actually, that is something we
So,
offer.
oh, okay.
In a larger.
So, yeah, actually, no, my wife is here. She just reminded me we do have a larger package where we do, in some of our paid programs, where we do some training on how to recognize some of that stuff. So, any other questions on that? This is our little kitty Cinderella.
She's beautiful.
Hi, Cindy.
All right, so the next legal blunder has to do with your contractual language, and so we'll just run into that here. The law of contracts is fairly simple. It's just about making sure that everyone understands their rights and obligations and lives up to them when they interact with one another. There are things that contracts can do. They can define the scope and the nature of the relationship between the people, and they can create boundaries and limitations, and they can give you rights and duties. There are some things contracts cannot do. They cannot override the law. They cannot violate public policy. So, for example, you cannot have a contract that requires someone to commit a crime, or you can't have a contract that requires them to discriminate against somebody, because those would be against the law or public policy. So that sort of contract would not be valid. And if you want to maximize your protection legally, there are a number of things that must be in your contracts, and there are a few things that absolutely should not be in your contracts in your coaching business. So we'll touch on those. And some things you want to think about. One is, do you have everyone sign their own contract or agreement with you? Do you go over the agreement with them personally? Do you give them a chance to ask questions that you can answer? These are all things that the more you do, then the less risk you have. So the more that you have everyone sign a contract, the more that you go over it with them and give them an opportunity to ask questions, then those are all things that reduce your risk. You need to be aware of where you got the contractual language, and are you familiar with everything in it. So familiar that you can answer any questions confidently. So did you have an attorney draft the contract specifically for you so that it's focused on your business and all of your specific risks and business model? Did you get the language from a training program somewhere? Did you get the contract for free off the internet? Did you write it yourself? I mean, there's any number of ways you can come up with contracts for your coaching programs and your coaching clients. And not every source of the language is equal. So I have seen some of my clients that I've worked with, when I started looking over their contracts, I was like, where did you get this? This is awful. And they said, well, I went to this coaching training program. I paid $10,000 for this year-long program. And they said, here's a sample contract I can use with my clients. And the contract was not only missing important things, it contained extra language in it that should not have been there, and that put the coach at huge risk if it ever got into the light of day. So you would think that if you spent a lot of money for a coach training program that they would give you some decent documents to start with. I found it turns out to be the opposite. So I'm not quite sure why that happens, or why they're not having attorneys review that stuff before they give it to their clients, but it's very dangerous. And an important point, if there's ambiguity in your contract, it's resolved against you. So that comes from a general legal rule that says that if there's any part of the contract that's not clear, and there's an argument over what it means, that argument is resolved against the person who drafted the contract. And here, even if you didn't literally write the contract yourself, if you're dealing with a coaching client, you're considered the drafter of the contract because you're providing the contractual language. So if something in that is not clear and it later goes to court over it, that provision will be resolved against you. So that's why you want to make sure you're very clear about everything that's in your contract, and that the language is good and that you understand all of it. So let's go over some things that do need to go in your contract. Obviously, you want a description of your program, and the clearer the better. You should have some detail that the client clearly understands everything they're getting, that they're purchasing from you, but you do need to find a balance. You don't want extra detail that doesn't really need to be in there. It doesn't need to be so detailed that it clutters up your contract. So if the minimum detail you need to clearly describe everything that's being purchased, that's kind of what you go for, and don't go beyond that. But if it's part of the package that they're purchasing, then it should be described in there. Your contract needs some good language on the limitation of the nature of your services. And this has to do with kind of the difference between therapy and coaching, or law and coaching. So as in your coaching practice, you're presumably not providing therapy or medical or legal services. So your contract needs to state that very clearly. It should state in there so the client has a place where they can read it and sign off on it. I actually have clients initial next to these provisions saying, so that my coaching contracts, they understand up front that I'm not providing therapy or medicine or legal services. And so I even do that on legal services in my coaching contract, because if I'm bringing someone on as a legal client, then I do that through my legal practice, and that's a whole separate thing. But if they're a coaching client, then I cannot provide legal services to them. They need to be switched over to my legal practice if what they need is true legal advice. And so then same thing in the contracts I draft for my clients. I put very clear language in there, and then always make sure that you have the client initial off next to it, so they can never claim later that they just glossed over it or didn't understand that part. And then again, understanding local law and the concept I talked about, how you can't call a sheep a dog, and the language doesn't override the local law. And being in a group doesn't put you in the clear by itself. Sometimes it can be, depending on the nature or size of the group, being in a group can be a little bit less risky than one-on-one coaching. But for example, therapy, licensed therapy with a licensed therapist or counselor can be conducted in groups. So simply the fact that you're in a group does not by itself, put you in the clear. So you still need that language clarifying of what you're doing is not therapy. Your contract should clearly spell out the payment information. I use the contract, or the concept of the contract is the receipt itself. So I have a line in there where I actually acknowledge receipt of the payment and I initial next to it, and then I don't issue a separate receipt to the client. So the contract is the receipt. One key thing, if you have the client pay in installments, I have a couple of things to keep in mind. Number one is the length of the installments should never be longer than the length of your program. And I have worked with coaches who say they had a 3-month-long program, but the client paid in 6 months installments. Well, if the client stops paying in month 4, what are you going to do about it? And the answer is nothing. You're just out that money. You can't kick them out of the program because the program's over. And you're not going to hire a lawyer and spend thousands of dollars in court going after a payment for a few $100 or whatever it is. So the installment payments should not last longer than the program itself. And if you do have installment payments, you need very clear language for payment authorization for the future payments. I have seen in some of my clients' contracts where they just sort of, it's like everybody assumed that they would be deducting payments from the client's credit card for the next 6 months. And that was kind of assumed in the contract, but it didn't actually say it explicitly. Nowhere did the client actually say in the contract, yes, I'm giving you permission to take the payment out of my credit card for the next 6 months. If you don't state that clearly, then you don't have the legal right to keep taking those payments out. And that may not be a problem with a lot of clients, but if a client challenges that payment with their credit card company, and the credit card company looks at the contract, they're going to side with the client, and you're not going to be able to get those payments back. You should spell out your policy on missed or canceled sessions. So when you're having, and this applies more for one-on-one coaching, but it can for in some small groups as well. If someone cancels the session late, or if they just don't show up for it, do you have some kind of fee or charge, or do they forfeit the session? There's any number of ways you can handle that, and how you handle that is up to you. There's no right answer. You can charge the full amount for the session. You can charge $50, $20, or you can just tell them that if you miss it, you forfeit that session, if you don't reschedule it in a timely manner. But whatever that policy is, it should be in your contract with your clients, and you should apply it clearly and consistently across the board. And then your contract should spell out your basic principles on privacy protection. So obviously you want your client to trust you. So you should state in there, hey, I am going to protect your privacy. I'm not going to release your personal information to other people without your permission. But there are legal limitations on that privacy. This is because this is not a licensed activity. There is no legal privilege. So if you were a therapist or a doctor or a lawyer talking to your client, then that conversation is completely legally privileged, which means that you absolutely cannot give up the client's information or communications without their permission. Even if you get subpoenaed, even if the police ask you, you cannot give up the client's information without the client's permission if it's legally privileged. But coaching is not legally privileged. So you can make a good faith effort and take all reasonable steps to protect your client's information. But if you get subpoenaed or if the police come knocking, then you may still have to release your client's information, even without your client's permission. Otherwise, you risk being in contempt of court. And because of that, I recommend that you put that limitation in your contract up front so that the client is aware of that. I dealt with a coach who had a instance of getting subpoenaed and having to answer it and give up some of the client's personal information on a fairly personal subject, like concerning how they knew the client had an affair. And they didn't want to give up the client's information, but it was that or go to jail for contempt of court. So they end up answering the subpoena, and then the client sued the coach for violating the privacy protections in their contract. Yeah, Adele.
I'm thinking I've recently done some work coaching with somebody else, and they've always used numbers rather than my name on everything. So it's kind of, they know who it is, and they have a reference. But if anyone ever found the book, they wouldn't know who on earth it was that they were dealing with. Is it sensible to use something like that instead, and would that help?
I think that's perfectly fine to do. That's an extra layer of protection to give your clients. Now, if a court or the police came to you and said, tell me who's, if they get a contract that says client 123 and the court says you have to tell me who client 123 is, then you still have to tell them. So you would still have to give that information to courts and law enforcement potentially, but it is a good extra layer of protection in case somebody, hacks into your computer or finds your records or files lying around. So it's not a bad idea.
It gives the client an extra comfort as well that you're doing everything you can possibly to protect them.
Yeah, exactly. No, and that's what you want as a client, to trust you. And so as long as you're clear with them that, hey, there are legal limitations, that if I get subpoenaed, I will have to answer that subpoena, but anything short of that, I'm going to try and protect you. And then, like you said, that shows the client that you really are trying and making that effort. I think it's a good idea. Your contract, of course, and this is a big part of it, needs to have some liability waivers. And so the difference between liability and indemnity is key. Liability is a liability waiver is when the client agrees that they are not going to hold you responsible for any injury or damage or losses that they suffer. So there's all kinds of things that can happen in this world where the client may make decisions based on the conversations you have with them, and that those decisions could then result in the client suffering some damage or loss of some kind. But you don't want to be held liable for that, because the outcome of those sorts of things are dependent on so many things that are outside of your control. So the liability waiver is the client agreeing they are not going to hold you responsible for it. Indemnity is the concept of the client making sure that they protect you against liability to third parties. So the classic sort of example is the client is on their way to meet you for a coaching session in person, and they get in a car accident on the way there and hurt somebody else. Well, that third party who they hurt, they might sue your client, but they might also sue you because the client was coming to see you. So in the indemnity provision is where the client agrees to indemnify you or protect you against any lawsuits from third parties. You want to have your policy on terminations and refunds. So I've seen a lot of contracts that are missing termination clauses. So, I mean, generally you have the right to terminate the agreement for any reason at any time, but that should be stated in there. And any consequences of you terminating it should be stated in there. So if you terminate it halfway through, do you give them half your money back? Or are you only going to terminate it for certain causes, like if the client lies to you, or does something else, commits some sort of breach of the contract? You want to say in there, when is the client allowed to terminate the contract, and do they get a refund or not? And then also your general refund policy. Is it conditional or is it unconditional? So a lot of coaches now have like a 30-day, you can get your money back for any reason sort of policy. But more and more now, some are going to a conditional refund policy where they say you can get your money back, but you have to show me that you've made a good faith effort. So you've come to the coaching sessions, you've done the worksheets, you've taken the advice, you've actually tried to do things a certain way. And if you do all that and you're still not happy with the results, then you can get a refund. There's no right or wrong answer to what your refund policy should be, or if you have one at all. Personally, I don't have a refund policy for a number of reasons. But whatever that policy is, it should just be stated clearly in the contract and apply it consistently across the board. When it comes to dispute resolution, so how do you resolve arguments that happen over your contract? So if the client has an argument saying, hey, I thought I bought X, Y, Z, and you say, well, no, you only bought X and Y, but not Z. And then there's a dispute over that. You want to have it spelled out in the contract that, number one, you guys should try to work it out like friendly and in person first. And only after that do you go to arbitration or mediation. And you can put a provision in there saying that the client has to go to arbitration before they go to court. that can be mandatory or optional. I usually advise making it optional because there are some states and countries where you're not allowed to have a mandatory arbitration provision. And it's not really practical to have, 25 or 50 different contracts for every different place you might operate. So I usually just make that provision optional. And then, of course, there's the boring but very important, we call it the legal mumbo jumbo, that should be in any sort of contract like this. One of them is called choice of law. So we talked earlier about which state or country's laws apply when it comes to determining if you are crossing some sort of therapy or some sort of line into a licensed practice like therapy or law. That's the law where the client is located. But when it comes to a dispute about the contractual language itself, you can choose whose laws govern. So you can have a choice of law paragraph that says if there's a dispute about this contract, it will be resolved under the laws of the United Kingdom, or the laws of California, or the laws of Ohio, or wherever. You can choose wherever that is. And I would generally recommend choosing your location so that any dispute would be resolved in the courts where you're already located. You need a severability paragraph. And so that's exactly what it sounds like. It's severing one provision off from the rest of the contract. The general rule is that if one paragraph of your contract is later found to be invalid, and it could be for any number of reasons, it could be found to be invalid. Maybe it's vague, it's not worded properly, maybe it violates the law for some reason. The general rule is that if one portion is found to be invalid, then the entire contract is found to be invalid, and you definitely don't want that. So you have a severability paragraph in there that severs off the invalid portion. It says, if any portion of this contract is found to be invalid, then the rest of the contract survives. And as long as you have that in there, then if you later go to court and the court says, hey, paragraph 5 is no good, then you can throw out paragraph 5, but the rest of the contract still is in effect. Yeah.
I've noticed a huge amount of increase of mumbo jumbo, as we say, on legal. Anything that you do online, basically, you have to click through a whole stream of pages of information, and
Yeah.
nobody ever reads it, or you can't. You'd spend all your life reading.
Yeah.
If you want something, you have to sign for it, don't you? You just have to say, yes, I accept.
Right. It's unfortunate, but it's the world we live in too. So if you are missing one of those important provisions at just the wrong time, you could be in a whole heap of trouble. So, but when it comes to your contracts with your clients, that's why I actually recommend you sit down with them, whether it's in person or on Zoom or whatever, and go over the contract personally. So at least they're getting some personal attention. They're not just left to read the contract on their own or skim through it. You actually go through it with them, and then the client sees that this stuff is important to you. They see that you care, that they understand it. So I think it actually, it can help with your relationship with the client if you're going through it with them.
I mean, you're the person to say, but I would have thought that all these things that are online that just say I accept to be able to get whatever it is wouldn't actually be legal, because no one really ever gets to. It's not a two-way thing, is it?
Well, right. Well, it's not really meeting of the minds or equal bargaining power. No, you're right. So those are definitely at higher risk of being overturned or not respected. That's another reason to sit down with your client and go over the contract personally with them and answer all their questions. If you do that, it is much more likely that your contract is going to be held up in court later on. Because the client can never say, well, I didn't read it, I didn't understand it, I didn't have time for it, because you went over it personally with them. That may even be recorded in your session. You've had them initial next to some of the key components in it. So it's much more likely if you spend that time with your client. It's not just good for your client relationships. It's also makes your contract stronger and much more likely to hold up in court. If all you're doing is having them check off a box online before they purchase, and I'm not saying you should not do that. There are times, I definitely have clients do that before they purchase my online products. But if that's all they do, then you're right. The client, it's easy for them to say later on, oh, come on, like nobody reads that stuff. I don't understand it. You know, I had to do it. So you're absolutely right.
It makes it more professional as well, I guess. It gives a more professional look of everything.
Yeah, exactly. Yeah. So you want to make sure that any amendments or changes to your contract are in writing. So in contract law, written contracts are not the only things that are binding. Verbal contracts are binding too. So if your client calls you up one day and says, I would like this extra service from you and I'll pay you $100 to do it, and you say okay, you now have a binding verbal amendment to your agreement with them. And that's fine as far as it goes, but if later on there's a dispute about that, you now have no evidence of what that was. And let's say you and the client remember that conversation differently. Well, how do you prove who was right? So you should have a paragraph in your contract that says that any changes must be in writing and signed off by both parties. So that way, if your client calls you up and says, I'd like this extra service and I'll pay you extra money for it, you say that's totally fine. And then you write it up real quick and send it to them and have them sign off on it. And now it's effective because it satisfies the requirement in your contract that it be in writing, and you're more protected later on. So if there's some dispute, you can actually hold up the piece of paper and say, no, 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 this is what they agreed to. Here's what they signed off on. And then I've talked about initialing, and periodically throughout your contract in some of the more important places you want to have them initial. So I usually have them initial next to the provisions where it says you're not providing therapy or legal services. And I also have them initial next to the provision on where it says that I may have to answer a subpoena if I get subpoenaed and have to give up their personal information. So that's another big one. Another way to do it is to have them initial at the bottom of every page. Some of my clients do that. And then I did say there's some stuff that should not be in your contract. So the big category is what I call fluff. And these are unnecessary extra details about your program or offering, descriptions of your coaching methods, descriptions of yourself. This is descriptions of things that are not strictly what you're agreeing to with the client. You don't want that fluff in your contract. Not only does it have no legal effect, it doesn't help you at all. It could get you in trouble. So this is what I mean, but I've had some clients bring me their contracts to look over, and they got these as sample contracts from some very expensive, big name programs. They were full of extra fluff that had no legal reason to be in the contract. It certainly was not going to help them legally, and it could only serve to get them in trouble. Some of the fluff I've seen in there made it sound like what they were doing was therapy, or like what they were doing was practicing law. Well, you really don't want that fluff in there. And the same thing with anything that's really just marketing language. Your marketing language goes in your marketing, not in your legal contract with your client. Here's another one of our kitties. My wife and I, we have children, but our children are off and not at home anymore. So our children now are our little kitty cats. This is Jonesy, our little orange tabby. Jonesy went
the ones that travel with you.
They do. They travel everywhere with us. We're heading to Chicago in a couple of days, and we'll be throwing them in the van and taking them to a pet-friendly hotel in Chicago. They love to travel with us. We've always traveled with all of them since they were kittens. So to them, it's perfectly normal to go in the van or the car and go somewhere.
Yeah.
So they
I
love
had one that sat in my lap while we travelled.
Uh-huh.
His preferred place was actually in the sink in the camper van.
Oh, how
it was
funny.
a nice cozy little space.
Uh-huh. That's a nice cozy spot. This one, Jonesy, her preferred spot is on the driver's lap. Whoever's driving, she will be on the driver's lap. So
that wouldn't be legal in England.
Oh, it wouldn't? Oh, bummer. Oh, that would be hard to keep her off the lap. Jonesy went for a swim the other day. We live much of the time on a boat up in Napa, California. And Jonesy decided to jump off into the water. And she, I don't know if this is good or not, but she didn't freak out. She wasn't upset. She just swam back to the boat and jumped right back on and then waited patiently to come back inside. So I guess that's good. I know she can swim, but at the same time, I think she kind of liked it, and I don't want her jumping off into the water. So. Okay, so let's get on to the third blunder that we should avoid here today, and this talks about groups and live events. And I've had a lot of clients and just people I've met who don't create enough of a distinction between their one-on-one coaching and then their groups and live events programs. So groups have extra legal issues, typically dealing with privacy concerns among the members, and you're often using a lot of material in group programs, and you have intellectual property concerns. Your retreats and live events have a lot more liability risk than the rest of your coaching business, particularly when it has to do with physical injuries or possible physical injuries at the location, or when you're using media, artwork, music, and stuff like that. So these are issues that are specific to groups and live events, and if you don't treat those issues with the legal respect they deserve, then that can be a blunder that can get you in a lot of some very costly trouble. So when it comes to groups, you have extra privacy concerns. So of course, if you have and I generally recommend that your coaching contract for groups be different from your contract for one-on-one. So you have a one-on-one coaching contract for those clients, and then you have a group coaching contract for when you have groups. And in there, you want to spell out that this should be a safe space for all the attendees. So of course, you have the same language as in your one-on-one contract saying that you are going to protect their privacy to the best of your ability. But then you also need to say that they have a responsibility to protect one another's privacy, that they need to be able to trust each other as well as you. And then there are, of course, limitations. So again, you still have the same legal limitations, like this is not a privileged communication, but you should say in the contract that they should be careful what they share in the group, because you have no practical way to stop the group members from giving up each other's information. You can try to scare them or make it clear that you're taking it seriously, or appeal to them from a moral and ethical level that they should respect each other and not use each other's personal information, in any sort of wrong way. But as a practical matter, if you've got someone in your group who's just not a very nice person, and they're going to go out there and share another group member's personal information, you have no real way to stop them from doing that in advance. And once you find out about it, you can kick them out of the group, but the damage in a sense is already done. So you need to warn your group members that that's a possibility, and that as a practical matter, there's nothing you can do about it. And usually in groups, you're going to have some material you use, whether it's slides like these or worksheets or exercises. That is your creative and intellectual property. Make sure people understand that that's your intellectual property, and that they should not steal it or use it for their own purposes or profit or give it away or anything like that. When it comes to live events, this is another one where I recommend having a separate document. So you should have some sort of release form that everybody signs when they show up to a retreat or a live event. And you guys have probably all been to live events where you have to sign some sort of form. That needs a beefed up liability waiver. It needs some of the it needs some of the same liability language you have in your other contracts, but it needs to also cover any sort of physical injury or illness that might happen at the group itself, and make sure that you're not held responsible for any of that. You should always get some sort of insurance to cover your live event. You can get that separately pretty cheaply. So if you do not otherwise have insurance, you can get some live event insurance for as low as like $50 or $60. I've seen it that just covers that event, and that can be a pretty cheap way to have some peace of mind and avoid a lot of trouble. If you do have insurance, read your policy carefully. There's a good chance it does not cover injuries at your live events, and so you may have to get some sort of separate rider attached onto it. And then in the release that people sign when they show up to the event, you want to make sure that they agree to follow all the rules. So not just your rules and your staff's rules, but all the posted rules at the event location itself. And make sure they respect not only the other attendees, but they respect your staff and they respect the staff at the location. So if you've rented out a conference room at a hotel, the last thing you want is afterward the hotel say, hey, don't bother coming back next year. You know, your attendees were jerks to our staff. The hotel doesn't want that. You don't want that. That's not good for anybody. Again, protect your intellectual property. You're probably using some of your own work product there. You want to make sure that doesn't get stolen. And then you may have guest speakers and content providers, JV partners and such, and you want to make sure that their intellectual property is respected as well. If you're recording or taking any videos or anything, you would need people's permission to use those recordings, especially for marketing purposes. So you want to, in the form that they sign when they show up at the live event, make sure they're giving you a release and permission to use the recordings for your marketing in the future. And then there's the question of your use of media. We've all been to live events where during breaks or at the beginning or at the end, they play popular songs and stuff. Well, when you do that, do you have permission to play those songs? The fact that those are popular songs on the radio does not mean that they're in the public domain and that you can use them in your live event without permission. Those songs belong to the artist or the record company or both, and you need a license to play somebody else's music. So there are various services online that have catalogs of music, and so for some sort of low subscription fee, you get like a license that covers sometimes it's thousands or millions of choices, and then you can use anything in that catalog for your purposes. But I always recommend getting some sort of license. And sometimes the hotel or other location where you're holding your event will require that you have that sort of license because they don't want to get sued for violating an artist's rights either. So it is okay to ask for help on this. I mean, do you guys have any questions about any of that material? We have several websites. I mean, personalempowermentservices.com is our coaching business. And so you can see the services we have there and the help we have available. My legal practice is at northbaybusinessattorney.com. And on either one of those, there's a book consultation tab where if you wanted to talk to me about the kind of different issues you have and how I can help and all of that, you can book a free 20-minute phone consult.